Good afternoon, everyone. I'd like to welcome you to the Fairbanks Ethics Lecture Series, which we've been doing since 2005 every month during the academic year. My name is Paul Helft. I'm the director of the Fairbanks Center for Medical Ethics, and it's a pleasure to welcome you here. Before we get started with our lecture, we like at the beginning of our academic year to introduce our new fellows. We have a clinical ethics fellowship, and if you're interested in more information about it, you can talk to myself or Dr. Brian Leland, who's the director of the fellowship program. You can look at our website, and please, if you're interested, come and talk to us about it. We have the largest class that we've ever had this year with 10 fellows, and I would just like to briefly introduce them, have them stand when their name is called. You can hold your applause till the end. The first is Kate Briggs, who's a CPE second-year resident from Scotland. The second is Chris Mulry-Klausman, an ER patient experience liaison at IU Health West. Rebecca Kreitzer, who's a law clerk at Indiana Legal Services. Hannah Green, an operating room nurse from Riley Hospital for Children. Ariel Jefferson, IU Health Compliance Consultant. Jennifer Killebrew, a hospital patient advocate at IU Health Methodist Hospital. Sandra Sandy McCabe, urological surgeon at IU Health Saxony. George Sullivan Davis, who's a staff chaplain at St. Vincent Hospital. Ryan Van Nude, who's an advanced PhD student at Purdue University. And Stacy Stewart, who's the manager of corporate affairs risk management at IU Health Methodist. So we'd like to welcome our fellows for this year. Just a few bits of housekeeping. As a reminder, evaluations will get completed at the completion of the series. So at the completion of this 18-19 series, you'll get an email in May for the evaluations. We record these lectures. They're actually available on our website, which you can find at fairbankscenter.org, and they'll be broadcast live today. Our broadcast list has expanded rapidly, and it's growing, so thank you all for watching remotely. And we welcome our two newest sites to join the broadcast, IU Health J Hospital and the IU School of Dentistry. So please silence all of your electronic devices. Leave the auditorium to return all calls if you don't mind. So Dr. Comer has no relevant financial conflicts of interest to discuss. And it's my pleasure to introduce our friend and colleague, Dr. Amber Comer. She is an assistant professor of health sciences in the Indiana University School of Health and Human Sciences. She's a member of the Eskenazi Hospital Medical Ethics Committee and Consultation Service. Amber serves as an adjunct professor in both the Indiana University School of Medicine and the McKinney School of Law, and holds an appointment as an affiliate research scientist at the Regenstrief Institute. She has a PhD from the Indiana University Fairbanks School of Public Health and a JD from the Indiana University McKinney School of Law. She completed our Medical Ethics Fellowship at the Fairbanks Center for Medical Ethics in 2014 and was named an American Academy of Hospice and Palliative Medicine Research Scholar in 2018. Her research goal is reducing suffering for patients by improving the quality of medical decision-making, and her current research focuses on the underutilized role of palliative care for patients who have suffered severe stroke. Additionally, Amber researches the effect of healthcare consent laws on patient care hospitals, which is the topic of her conversation today, and her research on Indiana's healthcare consent laws contributed to the recent change to Indiana's law. So it's my pleasure to introduce Amber Comer. Thank you very much.
Hi, everyone. It's so wonderful to be here today speaking with you. As you'll find out throughout the lecture, this lecture actually started out as my fellowship project with the Fairbanks Center for Medical Ethics and then turned into something that's actually followed me throughout my career and led me to talking to you today. So if it wasn't for the Fairbanks Center for Medical Ethics, I wouldn't even be talking to you today. So I do acknowledge them and all of the people who helped me get to this point today. Chuck Norris is going to come with us today as I lecture because this can be a dry topic. I hope to make it fun and exciting. Chuck's going to help me because we're talking about laws, and sometimes that's not everybody's thing. But I'm going to try to make it fun, and I'm going to try to make it memorable so that you'll walk out with an increased knowledge of Indiana's healthcare consent law and how that applies to all of you in your practice. So before we start talking about the law, I want to give you guys a little bit of background that I think is really important. And the first thing is medical decision making, because this law is all about medical decision making. And what is medical decision making? Of course, you know, it's the patient's ability to make medical decisions. And when a patient cannot speak for him or herself, then they need someone else who can speak for them. And that's called incapacity. So it's actually incredibly common for patients in hospitals to be incapacitated and need someone to help make their medical decisions. In fact, a study by Dr. Torkey and many other people who are actually in this room right now found that 47.4% of older adults in Indiana hospitals lacked capacity and required a surrogate decision maker to help them make their decisions. And so this is a really important topic. So patients who commonly need help making medical decisions include patients who have suffered stroke and trauma, mental illness, psychosis, dementia, Parkinson's disease. It's a very long list, including, in fact, up to 95% of patients in the ICU. So you can see there's a lot of patients who are incapacitated and really do need help making their medical decisions. So before we move on and talk more about who makes these medical decisions for patients when they are unable to speak for themselves, I want to point out a little caveat, a little difference between competency and capacity. So competency, if someone is incompetent to make their own decisions, this is actually a legal determination. And this is a determination that's actually made by a judge in a court of law. And so this carries a little bit of a different weight than if someone lacks capacity, which is a medical determination, which is actually made usually by a physician. So in order to be incompetent, a patient would come with a guardianship. And so that patient is permanently incompetent, meaning they cannot make their own medical decisions without the help of their guardian until a judge says that they are no longer incompetent. Capacity is a little different. Because capacity is a medical judgment, it's actually, it ebbs and flows. It waxes and wanes. Someone can have capacity one day and maybe not have capacity the next day. And that can sort of come and go based on the patient's medical position and based on the course of their illness. So today we're going to talk a lot about medical capacity because that's the one that most patients lack if they're going to need help making decisions. So another little caveat I want to point out for everyone is this implied consent doctrine in emergency situations. So when we're talking about surrogates making decisions, it would be great if we had a surrogate in the emergency room or if there was an emergency situation. But if there is a threat to life, to loss of life or limb, there is an implied consent that the person would want to live. And so there's this exception for emergency situations. And in Indiana, there's not a specific law that says what exactly constitutes an emergency situation, but you have to use the reasonable person standard and say a reasonable person would want to live if they were in imminent peril. And of course, if someone has an out-of-hospital DNR order or has made an in-hospital DNR order, this wouldn't apply. Okay. So now we're on to legal surrogate decision makers, and that's what we're talking about today. We're talking about if you have a patient, they lack capacity, or they're incompetent, who makes the decisions for them? So there are multiple ways that you can identify who can make a decision for a patient who can't speak for him or herself. So the first way is through court order, and this is a guardianship. And don't worry, I'm going to go through each of these and explain what each of them are. The second way is appointment by the patient through a legal document, and this requires some aforethought on the part of the patient, meaning that they have to actually fill each one of these forms out before they become incapacitated. It cannot be filled out or completed once the patient lacks capacity. And if the patient, which most of them, by the way, will not fill these forms out, does not have one of these forms, then you would fall to the state healthcare consent law, which is why you all came today, because there's been a big change in that law. Okay, so the first one is a guardianship. So a guardianship, again, this is adjudicated by a judge in a courtroom. So a judge would say, this person, maybe they have severe dementia and they're no longer able to make decisions for themselves, so they need a guardian to make those decisions for them and to care for them. I do want to point out that there are actually two different types of guardianships that someone can hold. They can hold a guardianship over the person, so over their health care, or over their finances. So you can be the financial power of attorney and have a different person who's actually the healthcare power of attorney. So if someone says to you, I'm the power of attorney, you should say, is that healthcare or financial? because you can have two separate power of attorneys. By the way, I should put the website up here. There is now a guardianship website ran by the state of Indiana where you can actually type in a patient and see if they have a registered guardian on file. Well, I know I didn't make it. I wish I did, but it's there. I will give you all that information. But it's you can actually, it's like the first thing that comes up in Google. If you're like Indiana Guardian Registry, it comes up. You can see if a patient has a guardianship. And so it's not fail-proof, so do ask as well, but it's a good way to check if you suspect that maybe someone has a guardian and you want to find that out. So it's out there for you guys. Okay, so the next form is a healthcare power of attorney form. And this is a form that is actually notarized. So you'll know it's a healthcare power of attorney because it requires a notary of republic, not just witnesses. This actually carries more weight than a healthcare consent form, which we'll talk about next. This actually allows release from the hospital or healthcare facility, disposition of the patient's body, request of an autopsy, and the making of anatomical gifts. So it carries a little bit more weight than a healthcare representative form. But it's a little bit harder to get because it requires notarization. So if you're in a pinch, you can get a healthcare representative form, and you can find them on Cerner, actually. So they're available for all of you. This just requires the surrogate to appoint someone, and it requires a witness signature that's not the surrogate. So this is something where the nurse or the doctor or whoever is caring for the patient, if they have capacity and they want to appoint someone, they can do it through the healthcare representative form in the easiest way. However, this technically doesn't carry the weight of a healthcare power of attorney, so it carries the least amount of weight. Okay. So next we'll talk about an advance directive, which I want to point out that an advance directive is actually a combination of a healthcare power of attorney form and a living will. And those two documents combined is actually what makes an advance directive. An advance directive is wonderful because it gives you a healthcare surrogate and it gives you what the patient wanted. A really interesting caveat to an advance directive in living will is that there is only one state, and that's Texas, that allows protections for physicians who follow a patient's advance directive, their living will portion, over the surrogate's wishes. In every other state, you are ethically obligated to follow the advance directive, the living will piece of the advance directive, but you are not legally obligated. But I remind you, ethically, do the right thing, right? Do what the patient wanted if the case calls for it. So that's just something very interesting about a living will. So in Indiana, this is the bare minimum that you need to have to constitute a living will. I like to point it out. So this is actually in the Indiana law that you can, if you have this can be a living will. I like to point it out because it has a lot of challenges to it. So if somebody said that they do not wish to receive artificially supplied nutrition and hydration, if the effort to sustain life is futile or excessively burdensome, would you know when the care has become excessively futile or burdensome to the patient? Maybe, maybe not. So it's a little hard to interpret, but this is the bare minimum that you need. You can have a much more extensive living will, but this would be the bare minimum that you need under Indiana law to have a living will. So a patient can show up with this and a healthcare power of attorney form, and that would constitute an advance directive. So there's another form I want to bring your attention to, and it's called the Life Prolonging Declarations form, and it is available on the state of Indiana's website. And this form actually, patient can fill out, and it requires 2 witnesses, but in essence it says that you want absolutely everything, even if it's futile or burdensome. And so a patient can fill this out and can bring it to the hospital. They have not been seen very often in my experience and from what I've heard from other people who have practiced for many, many years. But they are out there, so it is possible that you could come across this at some point with a patient. But again, this is something else that someone can show up with to help express the wishes that they want for their care. So one of our most recent forms that a patient can fill out is the POST form, which is known as POST, Physician Order for Life-Sustaining Treatment in other states. The POST and the POST are synonymous. They're just called different things in different places. So the POST is a document that a terminally ill patient can fill out that actually allows them to make decisions about artificial nutrition and hydration, about whether or not they would want to be intubated, whether they want medications, and this is something that they would actually fill out with their healthcare provider and then sign. And so this is something that a patient may have that they can put into their medical record. But again, you have to be terminally ill to fill this out, so it wouldn't really apply to those of us who are healthy. Okay, so we've come to a break where I've taught you all about the forms that you can try to find that people can fill out to try to tell you what they want. But unfortunately, you're really not going to see those forms in most of the cases. In fact, between 80 and 95% of patients in the hospital who lack capacity are actually going to have their decision maker appointed through Indiana's Healthcare Consent Act, because people just don't really fill out healthcare power of attorneys or healthcare representative forms. They just don't. And there's many reasons why. In fact, there's a lot of studies, if you're interested, that give reasons why people don't fill these out. The most interesting thing that I think is that there's actually a very high percentage of people who have them but will not bring them to the hospital, because they believe that if they bring something to the hospital that says that they don't want extensive measures, that people will give up on them, that their care providers will kind of quit taking care of them, which of course is not the case, but it is in fact a fear of people's, according to studies, which is why they don't bring them to the hospital. So Indiana's healthcare consent law is incredibly important, because this is how we're going to determine who makes decisions for patients in most of the cases. And it's very exciting that we have a new law. For better or worse, it's there, it's new, it's going to open up some, and it's changed some stuff. Okay, so I wanted to tell you guys a little bit about the road to changing Indiana's law and the part that myself and other people in this room have played in changing this law. So I told you in the beginning, this actually started as my Fairbanks fellowship project. So I worked with Dr. Alexia Torkey, and she was my mentor. And when I was taking ethics call with Dr. Torkey during my fellowship, I realized that we had several patients, where there were some issues with surrogate decision maker. They had this loving, caring person who wanted to make decisions for them, but under Indiana law, they weren't able to do that. And that caused some problems with the patient's medical treatments and care. And I realized that this is actually a problem that comes up quite often in the hospitals. And so it started as my fellowship project, and I did a study to try to figure out exactly what the impact was of Indiana's healthcare consent law on patient care in Indiana hospitals. And so that led to several studies that were conducted. And if you guys are interested, you can go and read all about them and see what we found. But in essence, what we found is that most physicians, in fact, do not know Indiana's healthcare consent law. And I say physicians because under the law, they're the ones who are charged with implementing this law. They didn't even know the law. And what we found, though, is that even among those who knew the law, 98% of them were willing to violate it to allow, for instance, a grandchild to make decisions for a grandparent. So I like to say that they like to choose to do the ethical thing rather than the legal thing, which would be to not allow that grandchild to make the decisions. And so after taking all these findings, so some of these other things that we found is that in this last publication here, that surrogates, whether they are what we would call a legal surrogate under Indiana's old law or a non-legal surrogate, that they had the same characteristics and relationships with the patient. And so what we were finding is that there really wasn't a reason to not change the law. And so in 2015, we had the first bill presented to the legislature to try to change Indiana's law, and it was a no-go. It was a no-go again. And then we got a bill through last year that allowed grandchildren and grandparents to make medical decisions for each other. And that was the first step. And so that law came through, and when everyone realized that, hey, it didn't hurt anything. In fact, maybe it helped a little bit. The next year, we were so lucky to have Representative Kirchhoff actually put in a bill to actually make the law the way that it is today. And that's what we're going to talk about. And so there was a lot of people who were involved in changing this law. The Indiana State Medical Association was so kind as to help us when we were doing the research aspect of this, and they also helped by unanimously supporting a change every year. They voted to that as a group that they would support this change in the law. And so that's where we're at today. So here is the brand new law. For better or worse, this is what we have, and this is what I'm going to explain to you guys. I'm going to tell you what it is and how it's going to affect clinical practice. And in case you are concerned, don't worry. I'm going to follow up with a study to see if it actually changed patient care. So that will be my next lecture to all of you. So, okay, so the new law says that any of the following people may act as a surrogate: a spouse, a child, a parent, a sibling, a grandparent, a grandchild, or the nearest adult relative and the next degree of kinship, or even a friend. So Indiana's old law, in fact, it stopped here. It only allowed spouses, adult children, parents, and adult siblings to make decisions. And then last year it added grandparents and grandchildren. And this year now it has the full list, including friends, which I'm sure you can think of many instances where you have a patient who perhaps is elderly and their spouse has passed away and they don't have children, and maybe they have a friend who knows what they want. They love them, they care for them, they're at the bedside, but the patient did not fill out the requisite form, and so that friend was unable to make the medical decisions. So that changes now. So that is, they're allowed to make decisions. So I want to talk a bit about what actually constitutes a friend. So a friend must be an adult who has maintained regular contact with the individual and is familiar with the individual's activity, health, and religious or moral beliefs. So a friend is someone who it can't just be someone that you sort of know in passing. It has to be someone who actually knows you and knows what you may want. So another thing that's really important about this law is that it now provides a hierarchy. In the past, the decision makers, the spouse, the children, the siblings, they all had equal say. And there was no hierarchy. So for instance, if a spouse and children did not agree on the patient's care, there was no hierarchy of who had the final say in the medical decisions. And so a hierarchy has actually been added. And in fact, the way that the law was listed is actually the order of the new hierarchy. So spouse, adult child, parent, sibling, grandparent. So in case you were all wondering, if there's a spouse and a friend, the spouse is higher in the hierarchy. The spouse has final medical decision-making abilities. And so you would want to, when you're finding the surrogate, you want to go to the person who's the highest on the list to make decisions. So then your next question might be, well, what happens if there's 3 children and they're not all on the same page? Because that never happens, right? So there's actually now, in the new law, there's a way to actually resolve disputes. So the way that it works is that if there's multiple individuals at the same priority level, so say there are 3, the spouse has passed away, so the patient has 3 children, that's the next on the list, that's the highest on the hierarchy, then it actually goes to majority rules. And so to give you an example here, if you have 2 sons and a daughter and a son agree, but the son does not agree, it would be majority rules. And so they would go with whatever medical decision the green people wanted to make. And so this is something that is good and bad. So the good part of it is that we can finally move forward with medical decisions because we no longer have to wait until everybody's on the same page. And the bad part, of course, is that there's a potential for hurt feelings for the person the son over here, who really didn't want that decision to be made. And so while it will expedite medical decision making, it could create more issues with families. So I just want to give you the good, the bad, the ugly, the positive, the negative of this law. And so that's where we're at. So this was really a problem. There's been many consults. I know at Eskenazi, where I serve on the consultation service, we are constantly consulted because we have siblings or people on the same hierarchical tier that cannot come to a consensus, and it delays patient care. And so this will at least give us a way to sort of move forward in those instances. Now, I do want to point out, this doesn't mean that you should just forget about the person who doesn't agree and not try to get them on board. You should still try to get everyone on board because, remember, these are people with feelings and emotions, and they all have to live with whatever the result is of that medical decision. So Chuck Norris approves this hierarchy. All right. So who may not act as a surrogate? This is also new and important to this law. It is important to know that a spouse who is legally separated or who has put in a petition for dissolution, so they have filed for divorce, legal separation, or annulment, cannot make medical decisions. So even though they are technically legally still married, if they have filed for divorce, they can no longer make medical decisions for the patient. An individual who's subject to a protective order or court order that directs the individual to avoid contact with the patient cannot provide consent. So if you have a restraining order against someone, they cannot come in and make medical decisions. And the third is that if there's a pending criminal charge, which involves the individual trying to make decisions, who, in essence, is the alleged attacker of the victim, they cannot make decisions. So if there is a domestic abuse case, the husband cannot come in and make medical decisions for the wife if he is the alleged attacker. And so this is something that is actually new to the law, because in the past this has come up. Okay, so the next thing that we move to is, okay, so now we know who can act as a surrogate. We have a much bigger list of people who can act as surrogate. We now have a hierarchy of a final decision maker, and we even have a way to resolve disputes if everyone doesn't agree. So how are we supposed to be making these decisions? So there's two different ways in ethics to actually go about trying to make decisions, and it's substituted judgment and best interest. So substituted judgment is where you try to make the decision that you think the patient would have wanted. So what, in essence, you try to put yourself in the patient's shoes and say, okay, this is what he or she would have really wanted me to do. Versus best interest, which is where you try to do what you think is actually in the best interest of the patient. So you can see that there could be times where what the patient would have wanted may not actually be in their best interest. And Indiana goes by a best interest standard. And so when a surrogate is making a decision, they should, of course, try to consider what the patient would want and try to follow the patient's wishes. We want to uphold autonomy. But in the end, Indiana law actually says we should make the decisions based off what's in the best interest of the patient, which, of course, what they wanted could also be in their best interest. So this standard gives a little bit more flexibility, and in fact, came out of a very interesting case where I believe it was in Missouri, where they were bringing in witnesses under substituted judgment to try to figure out whether this young woman would have wanted to be taken off of a ventilator. And the testimony that sort of won the day was a friend who said that they ran over, I think it was like a squirrel, and she saw it suffering and said, I'd never want to suffer like that. And so that's sort of where that came out of. Okay, so physicians in Indiana have legal immunity for relying on their capacity assessment. So if a physician assesses a patient and they think that, yeah, they really don't have capacity to make a medical decision, the physician is protected from criminal prosecution, civil liability, and professional disciplinary action. And so if you're curious about how to assess a patient for capacity, there's different resources I can give you. In fact, I can send you slides on a lecture I give, but there is a way to assess a patient for capacity. And if you do that and you believe they don't have capacity, you're protected. Okay. So how do you identify a legal surrogate? What extent do you have to go to? So basically, Indiana put into the new law that there is a reasonable inquiry standard, which means that you have to do things like examine the medical records, look at the face sheet, to try to see who is it that may be in this patient's life making their decisions for them. You can go through the patient's personal effects. Maybe they have, I hate to say go through their wallet, but maybe they do have that. Maybe their phone, something. Under iPhones, there's an emergency contact list that you can get to without having a password into someone's phone. So that's a reasonable inquiry. It's actually just trying to figure out who the person is that should be making decisions for the patient. And the next part of that is that you have to try to contact the person who's the highest in the priority level. And you have to be diligent about that. Okay, so because I'm a professor, I'm not letting you leave without a pop quiz to make sure that you were all listening and you didn't fall asleep. So if you have an adult patient and they're incapacitated and they're unable to make their own decisions, and they don't have a healthcare power of attorney or healthcare representative form, who can make decisions for that patient? Yeah, it's all of them. I heard it. It's all of them. So you'd have to look at the situation and figure out who's the highest on the hierarchical list, right? But technically, all of these people could potentially make decisions for a patient based on the situation, which is a huge change from where we were at this time last year. So which one of these persons has final medical decision-making abilities? Who's the top of the hierarchy? Spouse, exactly. So actually, I think I may have listed this basically in hierarchical order, but that's the way it works, is that you go down the hierarchy and the person at the top has final decision. Now, I do want to point out again, it doesn't mean that you shouldn't try to get the spouse and the children together to come to a consensus on medical care. It just means if you come to an impasse and you cannot get them to agree, that you can look to the person at the top of the hierarchy to make that final decision. And then if there are multiple persons at the same level of priority who cannot come to a resolution on patient's care, how can that be resolved? Majority rules, that's right. That's very different. Again, that's a very different change. It used to be everyone had to agree. Now it's majority rules. And I do feel that I should point out that if you are in a case where you have a tied majority, so 4 children and they're 2 and 2, the law does not resolve that, so you would have to fall back to one of those persons getting a guardianship over the patient, which used to be what would happen for many of these situations. And now we're down to the time that you should need a guardianship is if there is a tie on the hierarchical level and that you cannot resolve. And so the law does actually resolve most of the issues that have arise from surrogate decision making. Okay, so what questions do you have for me? Yeah.
Okay, so let's say you go down the hierarchy and say they're not married and you go to the adult child and they say, I don't want to make decisions that, I wasn't close to my parent or whatever. I don't want to do it. Mm-hmm. Do you need to have them sign anything to say, hey, they've opted not to make decisions and we go down the list?
Yeah, so you can actually give your decision-making abilities to someone else. So if it's in the case of the child just stepping aside saying, hey, I don't want to do this, you can go down to the next person on the hierarchy. There is actually a place in the law, though, where you could sign and you could assign someone to speak for you and make those decisions. So it could work either way. So if this child said they didn't want to make the decisions and they didn't sign anything, you would just go to the parent. But if the child wanted to, there is a place under the law where they could assign someone else to make those decisions, like say their spouse, for instance. And so I know that sounds...
I'm just kind of asking because I've worked with families where there's been some inconsistency. Maybe they first say, no, I don't want to make decisions, go on. And then they don't agree with the decision the other person's making. And then, no, now I want to. Right. So just asking how you stop that.
The way you would resolve that is that the person that's at the top of the hierarchy would have final say. So if the law doesn't speak to how you would resolve that specifically, but if it went to court, they would most likely go with whoever was at the top of the hierarchy. And so, yeah, it's hard. The law cannot fix every single situation, but in those cases, the child could come back. And I could see that could happen.
So I have someone who texted in a question. Where does civil partner or live-in boyfriend fall in the list of hierarchy?
Yeah, that's a great question. So they would actually fall under friend because in Indiana, we do not recognize common law marriage. We do not recognize civil partnerships. So any of those types of relationships would actually fall under friend, which is something that other states actually do address. So there are some states that actually rank spouse and civil partner as being equal. Indiana does not. In common law marriage, they recognize common law marriage, but we do not. So they would actually fall under friend.
Do you know when the state website will update this information?
Is it which state website? Well,
Yes, directive information.
Oh.
It's outdated.
Oh, I don't know. I don't control that website.
Yeah, the Indiana State Department of Health, the website, it's outdated.
Is it?
Do you know when they will update it?
I don't. I don't actually, but maybe I can email them and ask them to change it because the law went into effect on July 1st, so it has actually been in effect for several months. So,
Amber, can you go back to the last slide so that the broadcast sites can see the phone number to text with questions? Thank you.
Hi, Amber. Brian Leland. That was absolutely phenomenal. I'm wondering, in your hierarchy, you have spouse, but thereafter everything is clarified to be adult child or adult, but you don't have to technically be an adult to get married. So does it need to be an adult spouse?
Really, that's a great question. So if they are married, then they actually are given adult status. So if you were married at 17, then the spouse would actually be able to make those decisions. It's the same quirky thing about how if you have a 16-year-old having a baby, the 16-year-old's mom and dad have decision-making over the 16-year-old, but the 16-year-old has decision-making over the baby. So
Thank you for clarifying that. It only comes up for me because I work in pediatric critical care, and there are rare instances where people with terminal illnesses that are less than 18 choose to get married so that they can have their wedding prior to their death, and then that becomes an issue. So I appreciate you clarifying.
It's a great question, and
I just wanted to ask, years ago when the law first went into effect, I was in another hospital situation working, and the chaplaincy department had the role of talking with individuals about executing these. Does that still continue? And I just wonder how that works at this.
Yeah, so this doesn't change any, and you're talking about executing healthcare.
Helping individuals when they entered the hospital, they began talking to them about getting these forms completed so that healthcare decisions could be known. I wondered if that still happens today and what department or what area covers that here.
Yeah. Okay. So I was going to say, I don't work at IU Health.
I thought somebody might know.
Yeah.
So every hospital at IU Health is currently a little different. Here at Methodist and at University, it is the chaplains who, when you receive an order for to fill out an advance directive, it is the chaplain. At Saxony, it's also the chaplain. I'm not familiar with all the hospitals. I came from Ball, and we were not the ones. It was the social workers. So I mean, the order also goes to the chaplains as well. And so I think anyone can sign it and help with the conversations. And I don't know how it is at Eskenazi, what Eskenazi does, whether it's social workers or chaplains.
Yeah, there's definitely a team who will come in and help at Eskenazi as well. And I think it can be social worker chaplains and actually even a nurse or a doctor has the ability to pull this form and fill it out with the patient if they would like to do that. And I would like to point out that just because the law has changed to try to fix these situations, it doesn't mean that people shouldn't fill these forms out. This law is supposed to be a fail-safe. It's supposed to be there just in case we don't have these forms. But unfortunately, as it turns out, we mostly just don't have the forms. But I don't know how to fix that.
So I have another text-in question. Many ex-spouses continue to live together and be a main support person. Could they make decisions as a friend?
They could. So if there was not someone else who was higher in the hierarchy who wanted to make those decisions, then they could as a friend. But if that were the case and there was children, the children could say, you know what, we actually would like the ex-spouse to make the decisions. And so this doesn't stop people from figuring out who the best decision maker is in their family and their network. It doesn't stop that. It just gives an order in case people can't agree, or in this case, it actually allows that ex-spouse to be able to make the decisions, because under the old law, the ex-spouse would have no ability to make decisions over that patient.
So Amber, one of the questions that has come up as we've been teaching this is the person who has been accused of the crime. Can you talk a little bit about where they have to be in the process?
Yeah.
And does that apply to children and adults?
Sure.
So sort of you made the comment about domestic abuse, but is that the night of, or how far along do they have to be adjudicated?
Yeah, so the law uses the word charged, which is very different than convicted. You can be charged of a crime. So the minute you're arrested, you're usually they charge you once they arrest you. And actually, under the law, they have only a certain amount of time that they can hold you under arrest before they charge you with a crime. And so once they charge you, once the prosecutor says we're charging you with this crime, they can no longer serve as the surrogate. And the law that should apply to adults and children. And this came up because this has come up in instances where the person who has committed, for instance, domestic abuse has been the one who would be making the decision on whether you extubate or not, which is really fascinating because if you extubate, then you're being charged with murder. But if you can keep the patient alive, then it's not murder, it's attempt murder, which is a very different charge. And so you do not want that person who has committed the assault being the one to make the decision on whether you extubate. And so that's finally been resolved with the law. Dr. Torkey?
Yeah, this is something I just wonder if you could reflect on, because I do think it's interesting. I mean, I think one thing that didn't change is that the Indiana law lists this kind of unusual idiosyncratic standard, which is good faith and best interest. And yet when we teach about surrogate decision making, we certainly encourage people to consider the patient's preferences to the extent that they're known.
Yeah.
So I'm just wondering, when you're doing ethics consults, how should we consider patient preferences if they're they seem like an ethical good standard, but they're not really part of the law?
Yeah, so that is such a great question, and it's one that I've actually grappled with a lot because Indiana law dictates ethics, which is so fascinating. It dictates an ethical standard of best interest. And so the way I like to think of it, or at least when I'm conducting ethics consults or teaching about this, is that you should always try to take into consideration what the patient would or would not have wanted for him or herself. And there are many instances where what the patient would want is what's in their best interest. In fact, you could argue that it's in their best interest because they wanted it. But there may be times where the patient a good example would be a patient who said, don't ever take my breathing tube away. Just don't let me die. Do not let me die. Well, if you were using substituted judgment, then you would never want to extubate that patient. But there may come a time where what's in their best interest is to allow them to die a peaceful, natural death through extubation. And so it is definitely something that you should always take what the patient wants into consideration. It's just in the end, if you want to follow Indiana law, then technically when you're taking that into consideration, then it should be what's in their best interest. So yeah, we have another case where ethics and the law are sort of competing, and I always find it so fascinating when the legislature mandates or dictates ethics, but they have in this case.
I have another text-in question. So this is in-laws. How do daughter-in-laws and son-in-laws fall into the place in hierarchy? Are they considered adult children?
That's a great question. So in Indiana, I would actually say that they would be considered friends, and in fact, stepchildren as well. So the law doesn't speak specifically to whether or not stepchildren or in-laws are considered children. So what I would actually fall to give you that answer, and I could be wrong, I am just going through trying to think this through, is if you fall to trust and estates law in Indiana, it explicitly states that stepchildren and in-laws are not children that can inherit under trust and estates law. And so that hasn't been adjudicated and it hasn't been written into the law, but if I were going to argue that case, I would fall to trust and estates law and say, well, here in the legislature, they have said that they do not recognize in-laws and stepchildren as being children. So if you have stepchildren that you want to inherit in your will, please put them in your will.
Way to kind of avoid all this also is your healthcare representative form. If you want your daughter-in-law your stepchild to be your spokesperson, then your healthcare representative trumps everything.
Yeah, in a perfect world, we don't even need this law because everybody's already filled out their forms. It's just, unfortunately, people don't. I think it's hard to think about these things, and so people, they don't want to talk about death and dying, and so they just don't. Yeah. Any other questions? Yeah. It's good. We got plenty of time. This is fun.
This is a little bit of a quirky point of information, but the post form in Indiana, they keep kind of changing the form. And the latest changes they've made to the form is they actually took the healthcare representative off the back of it, which, I wasn't exactly very excited about. I thought it was nice to be able to do them on the same form, but it's not on there anymore, which is important to know. But another quirky thing is that in order for a surrogate to do a post form, they're technically supposed to be a named healthcare representative and not just one of these people on the list.
Right.
And so a couple things, it's important. So I feel like whenever I do a post form with a patient, I really try hard to encourage them to do a healthcare rep form, because if they lose capacity, that form can't actually be changed. Right. But now you have to do two forms. So it's just kind of important to know that. Unfortunately, they took the healthcare rep off the back of the post form.
Yeah.
I thought it was actually nice to have it on there, but it's not there anymore.
Yeah, they took it off because I think it was causing some issues with what if you have a healthcare representative on the post form, but you also have a healthcare power of attorney or healthcare representative form that you signed that has somebody else and who has the power to control, and so they took it off altogether. And that, I'm really glad you brought that up, because that is a really good thing to know, that if patients with a little A foresight, if they fill out that healthcare representative form or that healthcare power of attorney form, it can really change the outcome of their care.
How is the law or the form impacted if the person gets ill and they're out of state or out of the country? Does Indiana law still step in for them, or what
if
law
the
do they
surrogate's
follow?
out of the state?
No, if the person is sick and they're like they get sick in another country or another state?
Like an Indiana resident gets sick in like
Yes.
Chicago.
Yes. Does that impact anything?
Yeah, so actually, whatever state you're in, that state's law actually mandates what happens to you. And so, if you like the new law, I hope you get sick in Chicago. And if you don't like the new law, don't get sick in many other states that have laws that are not as extensive as this. And so, it's whatever state you're in, that's the state that controls. So, if somebody's vacationing in Indiana, they would actually be subject to Indiana law.
All right, I have another text-in question. Is there an effort underway to establish a state-sponsored advanced directive registry?
It's a great question. So advanced directives are actually not really in my purview, so I can't speak to that. I know that it has come up numerous times, and it has been done in other states. And I can also tell you that the state of Indiana offers a sample advanced directive form that you can just fill out and that you can have. So you don't actually need to go to a lawyer. And I know it says healthcare power of attorney, but again, you don't actually need to go to a lawyer. The state of Indiana provides a form that you can print out, and guess what? You can get it notarized at your bank for free. Usually, most banks will do that for free. So you could take that healthcare power of attorney form the state of Indiana provides, you can go to your bank, have it notarized, and then you have it. Also, there's supposed to be a place in all of the medical record systems to actually upload these forms. So there is a place in Cerner for forms. If you're over at Eskenazi, there is a place in Epic for forms. And technically in Epic, it was supposed to send you an alert. I know that someone had a form, but I know it's not always doing that the way it's supposed to. But which means that we should probably go and look. And I know from other studies, I've been doing some educational studies, that people aren't looking.
You said the healthcare power of attorney just needs to be notarized. Does that also include the financial power of attorney? Can just be notarized, or does that need a lawyer?
So both of them require a notary, and so they're separate forms. So the state of Indiana, I don't know if they provide a financial power of attorney form. I'm not sure. I do know that they do have a healthcare power of attorney form. There's actually a very extensive forms. There's many extensive forms on that website. So a healthcare power of attorney form, an advanced directive living will form is there, where you can name a healthcare representative and fill out a living will. The life prolonging declarations form is there, and the post form is there. And those are all free and accessible to anyone who would like them.
All right, another text question. Thank you, everybody from our broadcast sites who's asking questions. Yeah. What if an infant needs medical care after birth, but their mom is incapacitated and the dad and mom are not married?
Yeah, so that actually, it would be the dad who would be allowed to make those medical decisions, because a parent has the ability to make decisions for a child. Whether or not they're married doesn't dictate who makes those decisions or whether they can make those decisions. So, and in Indiana, as soon as the dad there's a piece of paper that you fill out when the child's born saying that you're the dad. As soon as you fill that piece of paper out, you're considered the legal dad. And it doesn't require a paternity test or anything like that to fill that paper out.
So what if that paper doesn't get filled out before the mom expires?
Well,
So
the
the
father
paternity
can fill it
affidavit isn't-
out.
I'm sorry?
They would be the alleged father. And in fact, so they're not married. If you are married, I'll tell you this in Indiana, if you're married, you are the alleged father until proven otherwise. And if you're not married, they can fill out the form saying that they're the father. And if the mom dies, I can't remember if she needs to sign that form or not, because this is actually more of like a paternity law thing.
She does.
She does. I don't actually know. I'm sure the father would have to go to court to fill it out. I'm not actually exactly sure what would happen. That's a little bit outside my scope of practice. I've done a little paternity law, but that was a long, long time ago. I try not to go there anymore. It's messy.
Hi. So my question is about sort of the diagram you had with the siblings.
Yeah.
And the majority rules sort of a thing. Can you just speak briefly to majority of what? Like, if let's say there were 10 siblings, but 5 were in the hospital and 3 cared, and like, what is the majority of? Does it go that specific?
It's the majority of the people who are at that hierarchy level who are making decisions. And so if someone steps out and says, I want no part of this, and say there's 5, and one steps out and says, I don't want any part of this, then you need the majority of the 4 that are remaining. And so if there are 10 siblings, then you would need the majority of the 10. unless some start stepping out. And believe it or not, there have been cases I've been consulted on that have that many siblings. So it does happen.
So the hierarchy level is important in that, because if we have 4 siblings who are split, but four adult children who are split, and then maybe a sister or a brother or someone that they don't contribute to that majority. Is that correct?
Right. And I mean, the old sort of tale is always that you'll have 2 siblings at the bedside who all are like, okay, we're ready to extubate and allow mom to die a peaceful death. And then there's like that sibling from California that flies and stop everything, don't do it. Well, this law actually now prohibits that sibling from being able to stop everything. And in the past, you would have had to wait until that sibling got on board with the other ones. But now you can go with majority rules. These are great questions. You guys are really thinking this through. I love this.
Amber, what are your thoughts on the person top of the hierarchy making the decision to make the patient no information, to not only exclude the other people on the hierarchy from decision making, but from
Anna, I can't hear you. I'm sorry.
So my question is, what are your thoughts on the person who's at the top of the hierarchy using their authority to make the patient no information, to not only exclude the others from decision making, but from even knowing their status or visiting?
Yeah, that's a tough question. The law doesn't speak to that. The law just says that the person at the top of the hierarchy has final say. And so I suppose one could interpret that to mean that the spouse could stop anyone else from being allowed to know the status of the patient, because they are the person at the top of the hierarchy and they do have final decision making. And so it could be, even though it's not explicit in the law, it could be interpreted to mean that.
Okay, I have another text question. Is there a website that lists all the state's laws regarding advance directives, powers of attorney, etc.? Because some families are spread out over several states.
Sure.
There are a lot of great ones.
There's not a website, but there's a great publication by Comer and Dr. Torkey that actually does give a chart that gives every single state's law. And it goes through and says every state and who has the ability to make decisions and whether there's a hierarchy. And it gives reference to the law. So that's in these slides, and you are welcome to pull that. You can go there. It's the last page in the appendix.
So knowing that state laws change, because Indiana has already changed, there are a lot of really great websites. Lexi, do you have any that you want to recommend? I mean, sorry to put you on the spot, but there are a variety that do list state websites.
So, I mean, I think that a lot of states have information about this, and there is some information on the American Bar Association website, but I think Amber made one important point, which is the law that applies would be the law where the patient is sick. So even if you have siblings from California, the law that applies to the patient here at our hospital is Indiana law.
Right.
And so it's not necessarily necessary to know the law in other states unless you practice in other states. There are also great websites for kind of helping think about how to complete advanced directives and how to make tough decisions, like Prepare for Your Care and the Conversation Project. But yeah, I think the Indiana website provides the actual documents that you need.
Does. And I just want to caution you, the American Bar Association, that document is not accurate. It's not up to date. I reference it in publication. I reference it in my publication, but it is not up to date. So I do caution you in using that reference. And in fact, my publication is 2 years old, so it is not up to date with Indiana's law.
I think that there is a Center for Aging website that does list a lot of states. So there are some out there just kind of digging.
They need to start a website, inform people. Yeah. Sorry.
My question is related to children who we see more and more children right now being raised by aunts and uncles or grandparents, etc. When there is a court-appointed guardian, does that guardian supersede the parent?
Yes. So the guardian supersedes everyone always. So that is the top of the list of the hierarchy is guardian. So if there's a guardian, you have to go with the guardian. With children, with adults, it doesn't matter. That's the top. Which is why if there really truly is a place where people just cannot agree and they're really arguing, they can go to the court and try to procure guardianship, because that sort of puts everything, it ends the fight.
Sorry, self-confession. I came in a couple minutes late. Where do we get these slides? Or where do we get how do we get access to this?
We can send the slides to everyone that signed in. We can just do it that way. As long as you sign in with your email address, we can send out the slides.
And this lecture is recorded and will be on the website within the next week, the fcme.org, or no, fairbankscenter.org.
Yes.
All right, I have another text question. Any advice or observation on working over a long period of time to fix a broken process, like the Indiana consent law?
Any advice? Okay, so
Just a short answer.
Yeah, so
No, I'm
first
kidding.
off, don't give up because there were many tears involved. I got hate email. I actually got hate mail from people who were like, why would you change this? This is terrible. And I admit that when I was thinking it, I was like, well, this person's a trust and estates lawyer and I'm probably going to take their business, but I don't know. I had to try to make myself feel better. There are people who will hate this. There are people who will love this. It took a really long time. It took a lot of people. I had doors slammed in my face a lot. Also, it took a lot of people sort of being on your side. So I guess just don't give up. That's kind of the big thing. And it did help actually to have the evidence because to be honest, the first couple times I went, I didn't have my research studies done yet. So I came in with some good ideas, but not a lot of evidence to back it up. It really helped to go in and to be able to say, this is what we found. This is how this law is affecting patients. This is how it's affecting physicians. This is how this is the effect that it's having. That was really helpful, I think, to convince people that we needed a change. And so the next step is that I'm actually hoping to do a study of a national study of all of the laws to see what states have better laws than others and how different types of laws are affecting patient care differently. So that's sort of the next step to this. And if I find that it's best to try to change the laws, then I've actually been talking with Andre Carson's people in their office to try to see if we can maybe change the federal law. We'll see. I'll come back in like 10 years when that's done, if it ever gets done. But that's sort of the next step in the process is to try to see what we can do at a federal level.
I think we have one final question.
Just a comment. I used to work in population health with primary care. Thank you so much for this presentation. I would really encourage you to bring it out to like primary care physicians because that's where some of this decision making can really be effective while the patient is alert, oriented, able to make those decisions. So thank you so much for this and all the work you've done at the State House to try to change these laws.
Yeah, thank you. Are we done? Thank you guys for listening and asking awesome questions.